without further ado, I will let Anaria take it away.
Morning, everyone. Anaria, Rambus here. Hopefully some familiar faces out there. I can't see anyone, but hopefully you recognize me. Today we're going to discuss why employee-specific policies matter to build clarity, compliance, and trust to protect your business. Okay, just as a reminder or introduction, because some people may not know, we do have a survey available. There will be 3 questions throughout the presentation, and we'll prompt you on each one, just so you know that you can put your answer in the survey. You may put it in the chat, but in order to get credit, we suggest you put it in the survey, and the form is on this slide. All right, so we're going to go in 3 different sections for today's presentation. The first will be a basic overview of the importance of creating job descriptions. And then we're going to move on into including policies to ensure you are meeting legal requirements. So there we'll discuss immigration, like I-9 forms, background checks, FCRA, and discrimination or non-discrimination policies, and then harassment prevention policies as well. Finally, we'll discuss paid time off policies and the Michigan Earned Sick Time Act. We had tons of questions from the employment symposium regarding ESTA. So hopefully I answered some of those questions today. And if not, we can always circle back and discuss more in the future. So let's get started. First, the importance of creating job descriptions. Why does these job descriptions matter? It helps define essential duties. As an employee coming into the workspace, you want to understand and know, what am I supposed to do? What is my day-to-day to be successful in this position and to continue moving the organization forward? Second, you want to establish performance expectations. As the employer, you want your employees to know, what standards should I be meeting daily, quarterly, yearly? What should I do? How should I be progressing? We don't want people to stay stagnant in the workspace. So let's define what they should do. Clarify reporting structure and identify required qualifications. What do I need as an employee to qualify for this position? That should all be outlined in the job description for each position within your organization. Essential functions and legal protection. The important here is clarity. Clear identification of essential functions for each job or each position is critical. And it's essential for requests like disability accommodations, performance evaluations, and termination decisions. More specifically, for disability accommodations with the Americans with Disabilities Act, the job descriptions will show what requirements were necessary to perform the duties of the job. So you want to make sure that the responsibilities for that position align with the description that was provided when you're defending claims against regarding the ADA. And this is all, job descriptions is also what courts and agencies look to determine, again, what was necessary for this position. And regarding the accommodation requested, were you able to perform that when you applied? And does that align? For example, remote work, that's the big thing now, especially since COVID. Just for reference, I'm not a big fan of remote work. I like to come into the office, and I've always been that way, even when we had to work remote. So I know for some people, they really got used to that work environment, remote work was a big thing. And so when you are crafting your job descriptions, are these positions, do you need to be in person would being remote allow you to do your actual job and perform your duties. For instance, if you're a receptionist, it would be really difficult to greet guests and, connect them with who they're coming into the office for, or, get them coffee, get them water, and make sure that they are, being transitioned into the meeting that they're going to and whatnot. If you're remote, it's really difficult. It's not impossible, but it would be really difficult to do. So as a receptionist, if you're requesting remote work and you don't necessarily, the job description may not necessarily explicitly say in office work is necessary, but the job description requirements would require you to be in person.
So this is Ron. Good morning, everyone. I would also point out that job descriptions, and we run into this regularly, are really important, to the extent we are onboarding folks and doing pre-employment physicals. So one of the things we find regularly is many of our clients appropriately do pre-employment physicals for their workers to make sure that they are fit and can perform the duties of the job. That being said, what we find is many of our clients will send somebody off to their clinic or their medical facility or the physicians they're using to do pre-employment physicals, but they're giving the physician very little to work with. The physician doesn't have the job description, and the physician is left to kind of guess whether, based on a job title, whether the person can in fact perform the essential functions of the job. What we find, number one, is as part of doing pre-employment physicals, the worker should be sent with a copy of a pre-employment, with a copy of the job functions and duties to the physician for the pre-employment physical. And those essential functions should talk about bending, lifting, squatting, repetitive activities. Does the person have the ability to lift 25 pounds or 50 pounds, depending on the job? Do they work in hot environments or cold environments? Are they, continuously ambulating during their work? Those are things that a physician should be looking at as far as opining as to whether somebody is fit for the job. And you need those in the job description. Likewise, to the extent you're dealing down the road, somebody's been onboarded, they've worked for you for a significant period of time, and there's a work-related injury or there is a non-work-related injury, and we're talking about how do we return this person to work and whether we can accommodate an injury or a disability. Again, it remains imperative that we have a job description that we can send to a physician to say, can somebody perform the essential functions of their job? And again, we have objective criteria in the form of that job description that specifies what those specific functions are, so that an evaluating physician can opine as to whether those job functions can be performed. And again, these are areas that we don't always think about as far as how we would use these job descriptions. They're not merely for the benefit of the worker, but they can help us as the employer manage some rather difficult situations in the event we have a work-related injury or an injury that somebody incurs outside of work, and we're dealing with whether they are fit to return to the workplace.
Yes, absolutely. And that was a great transition into our next slide about the Equal Employment Opportunity Commission and the protection that job descriptions provide for employers in that to that regard. So there are some best practices that the EOC provides as far as job descriptions and how how it helps defend against claims like discrimination, failure to accommodate, or wrongful termination. For example, as far as discrimination, think about in a role where you are managing, it's two different managers managing two individuals or employees in the same role. They perform the same way, but there's no structure, there's no job discrimination. I'm sorry, there's no job description to outline how to make decisions for these specific employees. If one manager is making decisions one way and the other is making decisions another way because they're just using their discretion, they don't have any job descriptions or no structure or standard to go off of, it could be seen as discriminatory. So the EEOC would look to the job descriptions and say what was provided there. So of course, best practices number one is to have a job description. Ron made that abundantly clear. It's important to have a document regarding, these specific positions. And so you can show this is what was required. And then also review them annually. So it's not enough just to have a document that was created in the 1990s when the organization was established. You want to speak to your employees and see how has things changed. And you can do that however often is feasible, but that's something that we can help you with here as well. Reviewing your handbooks and your job descriptions and speaking to your employees to see how have your job evolved. What are you required to do now? And should we include that in our job description? Update them. And then avoid vagueness. So that's something that Ron hit on as well. Be as detailed as possible. It's never too much information because clarity is so important here. Also, when things change materially within that job, that's something you want to include because, as Ron said, if the job originally did not require any physical movements, or you didn't have to lift a 25-pound box, or you didn't have to do that. If that's what is required now, we should include that just so everyone is clear about what's the expectation. So what to include, you have physical requirements that you want to include in the specific job description, also certifications necessary or licenses necessary to complete or successfully accomplish the duties of the job, any supervisory authority, and work environment expectations. So we spoke about remote work, but is that something that you want to provide for? If not, let's keep it consistent across the board, and in-person work is mandatory, unless obviously, things happen and you want to make a change.
I just want to follow up on something, and as Anaria is indicating, for all of you that are participating here as human resource professionals, this is one of those areas that's kind of difficult for us. We generally are working in our office. We're managing issues that come up on a daily basis. We're dealing with performance issues. Developing these job descriptions is not an easy task, and it really requires you getting out there, kind of observing what folks are doing, talking with managers, supervisors, and team leads to help better describe what the work functions are and what people are doing, understanding what tools folks are using on a daily basis. Again, it's difficult, to sit in our offices and develop a job description for folks. It's really important that we do some survey, that we get out, we see what's happening on the floor in the workplace, and what somebody's day looks like. So I encourage you, there are, some of us, and I'm no exception, we've been spoiled by AI, we've been spoiled by the forms that we can get online and things like that. But this is one that we really have to get our arms around, and we have to go out and we have to see what our people are doing and how they're engaging on a daily basis. I do want to point one thing out, and I'm just, you know, we're talking about physical function right now, whether somebody can lift, whether they can bend, whether they can squat, whether they can twist, whether they can lift their hands up over, their arms over their head, whether they can do repetitive activities at a keyboard. But it's all right to put in some of those emotional interactive provisions as well. Don't hesitate to put in that somebody has to be able to work cooperatively and constructively with coworkers. They have to be able to interact in an appropriate fashion. They have to have coping skills to deal with stress and workplace pressures. Some of those issues are just as important as the physical issues that we are talking about here, and probably maybe in fact more important. And the ability to have, whether we call it, emotional maturity within the workplace, and dealing in high stress situations, managing multiple issues at a given time, interacting, appropriately with customers, clients. Those are just as important, and we should be looking at those when we develop these job descriptions.
Yes, absolutely. I 100% agree. The physical requirements are easy to spot and easy to identify, but that's where that surveying will really come in to help with the emotional demands of a specific position that you don't, as the employer, you may not work in every single day. And then finally, as far as risk reduction for employers, performance evaluations, you can provide those within the job description as well. Of course, like I mentioned, at the actual day-to-day and any organizational chart, I think the goal here just across the board is providing as much detail as possible in covering all of our bases as far as how we're crafting these job descriptions. And as Ron mentioned, I'm not saying this by any means to say that it's easy to do. It'll take some time, but I think it's a high reward if you do take the time to identify what your employees are doing and what their duties require. So we're coming up on our first question. Again, there's a QR code that you can scan at the bottom of the screen to answer within the survey. According to the EOC, what information should be included in job descriptions? Okay, here's our answer. Were you able to access the survey?
I didn't come in yet.
Okay, no problem. Just making sure. Okay, so now we're going to talk about specific policies to ensure compliance. As mentioned earlier, we're going to go into I-9 forms, background checks, non-discrimination, and harassment prevention policies that'll all be helpful in ensuring your handbooks are complying with those federal laws and some state laws. I'll mention a little some state laws too. For immigration form, the requirements. So there are specific duties that we as employers have. First, verifying the identity of the employee or the candidate and the employment authorization of each person hired. Something I've learned is that there is e-verify systems in some states. Michigan doesn't require it, but some states do. It just it makes it easier because they can filter through and determine. They'll already know like the look back period for Michigan. I think that's like 7 years. So they'll look back for information for a candidate. And so that's something to keep in mind. Another duty that employers have is to complete and retain an I-9 form where where most of us should be familiar with the I-9 form, and employment eligibility verification. And then, of course, refrain from discriminating. We'll talk about this a little later, but against individuals on the basis of national origin, citizenship, or immigration status. And why do these written policies matter? Of course, it standardizes the onboarding process and it assigns responsibility, establishes procedure, and reduces exposure. And that is the goal. That's the point of having these policies. We want to reduce the risk, our risk as employers, and be as transparent as possible regarding our onboarding process. Okay, so background checks and the Fair Credit Reporting Act. So FARA is triggered when employers run background checks through a company or a third party in the business of compiling background information. The purpose is to promote accuracy, fairness, and privacy of information of the candidates and who will transition into employees. For these background checks, we suggest third-party companies because they know, again, like I said, that look back period for each state, which is 7 years. And something else that I wanted to mention in this regard is when you are conducting a background check is different from looking at public information. So if you're Googling someone, that doesn't necessarily trigger this act. But of course, we still suggest to conduct a formal background check because you won't be able to find as much information about someone as simply Googling them. But it's not considered Googling, it's not considered pulling background information through a third party. And so what is this background information that we are speaking about? We're talking about credit reports, criminal record checks, and consumer reports, right? So the best practices here is to have all applicants sign a background check authorization form. This can be, within the application where you are notifying the you're notifying the candidate that they will have to go through a formal background check process. And you can't seek the information as the employer. You can't seek information from references prior to obtaining this form. So it should be a part of your onboard checklist. This is something that needs to be signed, and we'll keep it in a personnel file. We're coming up on our second question here, where you can answer in the survey. To be FARA compliant when requesting a background check, employers must have a candidate sign.
And while people are answering, I just want to chime in and say, the form that Anaria is talking about should be a separate written form. It's not something that you throw in at the end of the application that says, oh, by the way, we might run a background check on you. It is a separate written document. It doesn't have to be long, doesn't have to be anything crazy, but it should be separate from any sort of application that the employee is signing.
The answer.
The other thing I would point out is that if you're using an outside source or an online source to secure background checks, sometimes some of these online sources, it appears that they are not requiring an FCRA waiver as a condition of doing the background check. You just send in, the information regarding the individual for whom you are securing a background check. I would encourage you that the burden and the liability and exposure falls to you as the employer or potential employer. to secure those documents. And, when you sign up for these online services, if you read the terms and conditions, they're very clear that you're making a representation that you have secured the appropriate FCRA waiver in order to get the information that you are requesting. So, I encourage you, if it's not part of your process, or if you are using older forms, I've had any number of folks that have embedded their FCRA waiver in their application, which, it's part of the document as opposed to being a freestanding document as required by the FCRA. This is, we talk about not having form over substance. This is really form over substance. You have to technically comply with the requirements of FCRA in order to avoid exposure or liability.
And we did have a question in the Q&A. Sorry, Anaria, before we move on.
No, it's okay. Go ahead.
Is there a requirement for filling out the form I-9 by hand? My understanding is that while, some of the answers can be typed in, the signature should be a wet signature. So that part at least should be signed by hand.
I would agree with you, Muriel. I haven't seen any guidance on DocuSign or anything like that, or whether, a lot of times in contracts and documents, we provide for execution of a document, online, where somebody can sign and scan it over to us. There hasn't been dispositive information made available regarding, immigration, and the ability to have something other than a wet signature. That being said, if you've ever gone through an I-9 audit, which none of us really want to go through that, the investigator will go through every section of that I-9. They'll make sure that the right boxes are checked, that the signatures are there, that the dates are there, and any one of those little problems, results in is deemed a violation. Now you have the ability to correct those things, but they are deemed violations.
Alrighty. So earlier I mentioned that we would speak about primarily federal law, but there are some state level FCRA issues, and they're not issues, but regardless, they're just that, federal law is one thing, but states have the ability to expand on those. They just can't limit those. And so some states have enacted laws that add requirements greater than the FCRA policies. And I thought it was important here, although we're here in Michigan, some of you may have offices in Arizona, Georgia, California, Maine, Massachusetts, Minnesota, New Jersey, New York, Oklahoma, and Washington, where those FCRA policies are expanded. So you want to ensure that you're complying not only with the baseline FCRA requirements, but also the state requirements, just to ensure compliance, because we'll talk about some damages moving forward. And so there are some notification requirements that employers must comply with. When you have to notify a job candidate before and after adverse action is taken based on information received from a consumer report. So a pre-adverse action report, before you reject an applicant, reassign, terminate an employee, deny a promotion, or take any adverse action based on information in a consumer report, you must give the applicant or the employee one notice that includes a copy of the consumer report you relied on, and two, a copy of a summary of your rights under the Fair Credit Reporting Act. It's a PDF document. I found it online. It's fairly simple or easy to find, but you want to give that to the or you can get it from the company in which you received the consumer report from. But either way, give those to the candidate or the employee. And then because this notice will give the person the opportunity to review the report and tell you if the information is accurate information. And then, so that's for pre-adverse action. Then for adverse action report, is when you take if you take adverse action, you must give the applicant or employee a notice of that fact orally, in writing, or electronically. This notice tells people about their rights to see information being reported about them, to correct, again, the inaccurate information if there is any. And so you want to include in this notice the name, address, and phone number of the company that you received the report from, a statement that the company supplied the report a statement that says that the company that supplied the report did not make the decision to take unfavorable action and can't give specific reasons for it, and a notice of the person's right to dispute the accuracy or completeness of any information from that company. Employers will also sometimes use investigative reports, and those are reports based on personal interviews concerning a person's character, reputation, characteristics, and lifestyle. And they have additional obligations under FCRA, which includes giving notice that you may request or have requested an investigative consumer report. And so these are all things in which you would have to give notice to the employee for if you're using any of that information and took adverse action or made any final decisions regarding it. Once you're done with the consumer report, you must securely dispose of the report and any information gathered within it. Again, the purpose of this is for privacy. And so you want to ensure that you're keeping this information confidential.
And Anaria, I would jump in and add at this point, and then we've got a question. This is an area that employers often overlook, or particularly if they're running a background check for an existing employee. It's easy to think, oh, I have to run the background check to make sure that I've done my appropriate check, and I have to run it, X number of every couple years, that kind of thing. But your obligations don't go away just because the employee is an existing employee. So this applies to both background checks conducted pre-hire and for those who are existing employees. And then we do have a question from an attendee. Is the notice for adverse action the same as a no hire or information found on a candidate when conducting a central registry check? If that central registry check is part of a background check, which it very likely is, you are still subject to those FCRA requirements, which means that you would need to give that pre-adverse action notice, because sometimes mistakes happen. Sometimes the report that comes back is not properly associated with your candidate. And so the purpose of the notice is to give the individual the opportunity to come back and say, I see what this says, that's not me. So the answer is yes. If that information comes from a background check, you do need to comply with the FCRA pre-adverse action notice requirements.
Alrighty, thank you, Mariel. So those damages that I mentioned earlier regarding, when you are not in compliance with the FCRA, consumers may seek actual damages. They may, if they're alleging a willful failure to comply with the FCRA requirement, they may seek actual statutory or punitive, which may include, they may recover costs and reasonable attorney's fees. So they're just costs associated or fees associated with violating this act. So what should strong policies include? When checks are required, who was reviewing the results of these background checks? Are there any individualized assessment procedures, and what are the confidentiality safeguards, which Ron and Muriel hit on while we were in this session? All right, so now we're going to discuss non-discrimination and harassment prevention statements. They're very similar, but I'll highlight the key differences in the best practices provided by the EEOC. We want to have this have statements for both. Because you want to identify to the employees and, as an employer, you want to know what is the type of conduct in which we are prohibiting in our business or in our organization. So for a statement of non-discrimination, the best practices is to state that discrimination based on race, color, religion, sex, national origin, disability, age, or genetic information will not be tolerated. It's strictly prohibited. And you want to provide definitions and examples, be as specific as possible here. But also in Michigan, in different states, they have different classes that they add in addition to the ones that were listed. So for instance, in Michigan, it's religion, race, color, national origin, genetic information, age, sex, marital status, height, weight, arrest record, or disability. So there are some differences there. You want to provide all of that within your statement of non-discrimination.
And I would just share, when we are responding to an EEOC charge of discrimination or a Michigan, Department of Civil Rights discrimination complaint, when we're dealing with the investigators, and even if we're dealing with a civil action, whether in state or federal court, I have to tell you, when we check the box, it's always important for us to have this policy in place so that we can, the first thing any investigator asks for is, do you have a non-discrimination policy? And again, we like to cite these things. We like to make sure we include them as far as our response. And we want to make sure that our policy is compliant and comprehensive. We have run into, issues where a policy merely says we comply with, Title VII or Elliott Larson civil rights. It's important for your workers to essentially see the recitation of the protected classes that we are protecting. And in many instances, an investigator or a compliance officer in one of these departments are going to be looking for those things to make sure that folks are very much aware. I mean, again, in Michigan is a little bit unique. Not every state protects height and weight. Those are things that we want to make sure we disclose. I have HR professionals, participating here. That in any number of workplaces, some of the banter that goes on shop floors goes to issues of height and weight and age in many instances as well. We want to be calling those things out on a regular basis.
Yes, absolutely. Another best practice as far as creating or drafting your statement for non-discrimination is you want to state that you'll provide reasonable accommodations to applicants and employees who need them for medical or religious reasons. Explain how employees may report these discrimination claims or any concerns that they have. Designate more than one person to receive and respond to these discrimination complaints or questions. Your employees may not feel comfortable going to that one person, or that one person may be the one violating this statement of non-discrimination. So have multiple reporting sources. Consider permitting employees to report discrimination to any manager. That just goes to the last point. You can state that employees will not be punished for reporting discrimination or participating in a discrimination investigation or lawsuit. You can state also that you will protect the confidentiality of employees who report this discrimination. The goal, of course, is to ensure that your employees are making these reports and what's going on within the workplace, so you can accommodate where necessary or make changes where necessary. You can provide for prompt and thorough, impartial investigation or complaints, and be transparent about the corrective and preventative action taken if necessary. Again, just for being transparent about the investigation process and ultimately, what is your final decision? What did you, as the employer, what do you want to decide to do? Similarly, for harassment prevention, you state that harassment based on those protected classes will not be tolerated. The same ones that we mentioned before, of course, with Michigan's additions. But also you can include sexual harassment, being explicit about sexual harassment in your statement of like harassment prevention statement. Excuse me. State that as prohibited in the workplace. And most of the other tips were very similar. Just be transparent about the process. How are employees supposed to make these reports? How can they do that? Who do they report to? Multiple people to report to. Okay, outline those within the statement. Put those positions, because obviously the people may change, but make sure the positions that the employees have the ability to report to are clearly outlined and defined. Respond to any harassment questions or concerns. Investigations should be prompt and effective. And ensure that your managers understand their role and responsibility to stop any harassment that's going on within the workplace, and that is that a complaint. Make sure that they understand that a complaint was made, and how should they address it, how should they handle it, and prevent it moving forward.
I would add these policies are so important, not just for us to respond to EEOC matters, but they provide guidance to your managers, because oftentimes your managers don't come in with the same HR background. And so having very clear policies that indicate, these are the steps when an employee files a complaint, and this is typically what it looks like, and this is the process, can help your managers. But then equally important is training your managers on your policies, because not every manager is going to know the handbook back to front. And while having these policies are good, if you're not implementing them or your managers don't know where to find them, then they're not doing as much good as they can be doing. So it's really important to have them, and it's very important to train your managers on how to implement policies and understand where to direct employees if they have questions about where to report.
Yeah, absolutely. I think throughout the presentation, I've mentioned employees and employers, but managers are employees too. So they need guidance on that as well. So thank you, Muriel. Okay, so we're getting to our section regarding paid time off policies in the Michigan Earned Sick Time Act. For paid time off policies, or PTO, there aren't federal laws regarding or requiring PTO, but as we all know, most employers, organizations have PTO policies. So it's important, if you do, to be clear about your policies. And there are risks associated with unclear policies. So we're going to talk about a little bit about that. Types of PTO, there's of course personal, and then we have vacation. So with personal, it's paid family leave, or for example, paid family leave, paid sick leave, paid bereavement. And for family leave, it's of course when you need time away for work to tend to your family members, or if you gave birth to a baby and your employer may continue to pay you during your absence. So that's something that will be outlined in the policy. So you'll have an understanding of how to use your paid time off effectively if anything were to happen. The same thing for sick leave. It enables you to take time off when you're addressing a health concern, or bereavement if you lost a loved one. I'm sure we all have heard of these different policies, and these are just the different types of personal things that you would take PTO for. And vacation, some employers lump it all together. as, just personal, but vacation obviously is when you're not going to be working. You're just taking a break from work. It's not like necessarily a reason or a health concern. It's just, this is my time away from work. And so some employers use it, again, they just lump it into PTO, but some it's completely separate. So again, if you want to separate that or lump it together, just make sure that it's outlined properly so the employees know how to use it. Again, as I mentioned, there are risks associated with having unclear policies. You could have errors in accrual, so under accrual or over accrual, improper denials of leave. When people absolutely need it, sometimes it's an emergency. Employees should know how to think fast in these situations. Okay, who do I contact? How do I go about taking PTO? I've had jobs in the past where that has been an issue, or other employees would, we have to come together and brainstorm, like, how does this work? And that shouldn't necessarily be the case. It should be, because a lot of these instances are emergency situations, it should be more, it could be clear. Retaliation claims is another risk, and then wage and hour disputes, that could be a risk as well. And so here's the big one. This was like I said, in our employment symposium, there were so many questions regarding ESTA. So the bulk of our time will be spent going through the different individuals covered by this act, accrual, what are the qualifying reasons? We'll go step by step. And so the Michigan Earned Sick Time Act, it provides exactly what it says, and it's, sick time for hours worked for employers. So there are certain employers that are covered, and I guess that's not even the best way to put it. Basically, all employers are covered in Michigan, and they do differentiate small businesses from regular or small businesses from everybody else. And that's because there are different hour requirements. So small businesses are businesses with 10 or fewer employees, and we'll get into the differences between the hours later. And exclusions here are rare unless you are a governmental entity. So like I said, mostly all employers here are covered, just bare bones. But if you have any questions, we'll be happy to answer or circle back with you if we don't have the answer at the moment. And then employees covered, again, it's very similar all, but there are some exceptions that we'll get into a little later. And so under the Earned Sick Time Act, employers must provide earned sick time, track accrual, allow use for qualifying reasons, and avoid retaliation. So accrual, this is where I said there is a difference between small businesses and all other businesses. And again, small businesses are those businesses with 10 or fewer employees. There, you'll accrue a minimum of 1 hour of 1 hour of earned sick time for every 30 hours worked, but you are not entitled to use more than 40 hours of paid earned sick time in a year. And so for every other business that's not a small business, so with 10 or more employees shall accrue a minimum of 1 hour of earned sick time for every 30 hours worked, but they shall not, their floor, I guess, is 72 hours of paid earned sick time. And I said floor because you as an employer can always provide more, but no less. And that's how accrual is tracked over time. Another method or an alternative method to tracking, or you don't necessarily have to track it, but providing earned sick time is called front loading. And it's where employers may provide the total amount of earned sick time all at once. And so these hours are available for immediate use. And And I mention that because for accrual, it's not necessarily, you don't have it when you first start, you have to work. So there is a 120 calendar day. You can have that 120 calendar day rule where employees are not allowed to use their accrued earned sick time until that 120th day. That's not a rule for front loading though.
Anaria, I'm going to jump in here because that was a change from, as I'm sure everyone on this call remembers, when this law was first passed. There was the initial version, and then right really at the 11th hour, the legislature came in and made some amendments. And one of the questions that we got quite a bit in that transition period was, I usually have a 90-day introductory period for my employees where they're not allowed to use any sort of paid time off, be it vacation or sick leave. And under the amended version of ESTA, so this is what you must follow. If you're using the accrued method, then you can have a waiting period of up to 120 days. Doesn't have to be. You can stick with your 90 days. You can add the up to 120 days. But you can have that waiting period. Now, it's important to note that during that 120 days, the employee is still accruing time. So it's not as if once they finish their 120th day, that's when they start accruing 1 hour for every 30 hours worked. It really means that on day 121, they have X number of ESTA hours ready to go. On the flip side, if you're doing a front loading method, you can have no waiting period for ESTA. It must be available for the employee to use immediately. And so where employers get a little bit tripped up, and I know Anaria is going to talk about this, but I'm just going to jump the gun a little bit, sorry. If you have a combined PTO policy where you're including your ESTA hours within your PTO bank, that's one area where you'll need to be careful and create a carve out, because employees must be able to use, if you're front loading, that sick leave time immediately.
Yes, 100%. Thank you for chiming in there. Because I know that's a lot of information and it may get lost in translation, but that's why I wanted to identify the difference between accrual and front loading. They're two separate things, and they have different requirements. And so hours that are distributed based on the benefit year. One thing I wanted to mention too is a benefit year is a regular and consecutive 12-month period determined by the employer that is used to calculate an eligible employee's benefits. Something that I wanted to mention here is for accrual, an employee may carry over or receive compensation for the hours unused going into the next benefit year. And that's up to the 40 hours or 72 hours, depending on if you're a small business or not. And the company decides, or the employer decides, which method that the employee will be compensated. So whether they're going to roll over those hours or if you're going to pay the employee for those hours unused that they accrued over that year. And so earlier I mentioned that there are some majority of employees and employers are covered, but for employees specifically, there are some exceptions, and those include being a governmental employee. One that is really prominent, of course, are unpaid trainees or interns, and individuals employed in accordance with the Youth Employee Standards Act, an individual who works in accordance with policy of an employer that allows individuals to schedule their own working hours. This is a very limited policy or rule or exception, I'm sorry. But if you had any questions regarding that, we would be happy to answer. And policies prohibiting the employer from taking adverse personnel action against the individual if the individual does not schedule a minimum number of working hours. And public officials, elected, appointed, or similar officers. And then lastly, volunteers. So under certain circumstances, they're generally not considered employees of the company.
Anaria, we have just a few questions in the question and answer, and I'll throw them out to anyone on the panel as well. So the first one is, If you have a 120-day waiting period to use ESTA and the employee quits or is fired prior to the 120 days, are you required to pay out their ESTA? I don't know if anybody else on the panel wants to take this one, or Anaria, if you've got it. Otherwise, I'm happy to handle. All right, I'll take it. So ESTA does not require a payout of unused time. The caveat is you must be clear in your policy that you don't pay out any unused accrued time. And so I know Anaria mentioned if you're using the accrual method, there is a rollover of time. In other words, you must allow the employee to carry over up to 72 or 40 hours, depending on your business size, of unused accrued time into the next benefit year, but you can cap the use at that 72 hours or 40 hours, regardless of the amount carried over. Alternatively, an employer can choose to pay out that unused accrued time at the end of that benefit year. So it's completely optional. And then upon termination, again, it is completely optional and up to you, the employer, but you want to be clear in your policy, because if your policy says that you pay it out, then you must pay it out upon termination pursuant to the Michigan Wage and Fringe Benefits Act. And similarly, if your policy isn't so clear, or maybe your policy doesn't say, but you've kind of developed this practice of paying out unused PTO because for whatever reason, that's just kind of been how you've been handling this, then you again are likely going to have to pay out that unused PTO. So, or excuse me, PTO or ESTA. So best practice is to be entirely clear, leave no question in your policy. If you do not want to pay out any sort of unused paid time off, including earned sick time, state it in your policy. Say any unused time is forfeited and will have no monetary value. Second question, if someone is overpaid related to the overuse of vacation time, can the employer recoup the funds? And is there a time frame for this? I understand the state of Michigan has a defined time frame. Again, if anyone on the panel wants to handle it, or Anaria, otherwise I can jump in.
Sure.
So under ESTA, I'll deal with ESTA first, and then we'll move into general vacation. But under ESTA, the law does provide a mechanism for you to recoup any overuse of vacation. In other words, if you front load the 72 hours for an employee, and they, let's say, take all 72 in February, but using that 1 hour for every 30 hours worked, they actually wouldn't have accrued the full 72 hours. ESTA does allow an employer to recoup the funds for that. Now, the analysis doesn't stop there, because although ESTA says, yeah, that's fine, you can obtain repayment, in practice, a lot of employers want to take that from the final paycheck, and that may not be a good idea, because you must obtain, again, under the Michigan Wage and Fringe Benefits Act, a separate signed writing by the employee authorizing you to deduct from their final pay. And then even if you have that, or from any paycheck really, even if you have that signed authorization, you still have to make sure that any deduction does not drop that employee below minimum wage. So although ESTA does permit that clawback, that's what I'll call it, you do have to remember there are other wage and hour laws at play here. And so the same is true for the overuse of vacation time. Yes, if maybe it's an accident, maybe the employee actually gained more time than they're really eligible for, depending on what your policy says, you may be able to claw that back or require repayment. It was an accident, but you are still subject to that Michigan Wage and Fringe Benefits Act. And so again, you have to have that separate signed writing. And then anything you deduct cannot be cause the employee to drop below minimum wage. Now, that time frame that you're looking at does come from that same act I just mentioned. If there has been an overpayment of wages or fringe benefits that's due to a miscalculation or some sort of error, then you do have to have that deduction occur within 6 months. And so there is kind of a time frame. It is important to note these mistakes early so that you can remedy them, and then know that just because you've spotted it doesn't mean you can automatically start deducting. Okay, we've got a couple more questions. Are you good, Anaria, for more questions? Okay, great. So attendee asked, can you say only pay out with a notice of resignation and not pay out for involuntary termination. The answer to this is a little tricky under ESTA. Prior to ESTA, I would say, yep, there's no law in Michigan that totally requires you to pay out any sort of leave, and so that's fine. You can make those carve outs as you want. Because ESTA has this non-retaliation period, I would just be careful, or non-retaliation language, excuse me. I would be careful with the way you draft that policy. So yes, you can say an employee who gives, X amount of notice is entitled to a payout, whereas an employee who is terminated involuntarily doesn't get any sort of payout. But what I often see with that 2-week period or however long notice period for resignation is this statement that says you have to give us notice and you can't use any PTO time during that period. And that's where you might get into trouble again if your sick leave is combined in your PTO. If an employee has ESTA available, you can't limit their use if they're using the leave for appropriate time or for an appropriate ESTA purpose. So I would be careful. You can create those caveats. You can say, under these conditions, you'll receive a payout, but just be careful that you're not running afoul of the new ESTA regulations. All right, go ahead, Anaria.
Okay, thank you for answering those two. So another important portion of ESTA, and it kind of goes within the common compliance mistakes, but not necessarily, it's fairly simple, in that it has posting and record keeping requirements and posting and notice requirements associated with ESTA. So for posting, employers must place a required poster from the state in their place of business or in the job. So this was a requirement starting last year. And also, employers must provide written notice to employees detailing their rights under ESTA within 30 days of the effective date. So we're well past that. That was, this was effective in 2025. And of course, in that poster, you want to summarize these rights, and it must be in a place or a location that's accessible to all employees. So you don't want it tucked away. You want it placed in a workplace environment or, somewhere where everyone has access to. And so there are some examples that I wanted to go through, and this may help answer some of those questions that we may or may not have. I don't have access to chat from here, but I thought these were very interesting examples in which, we may as employers get caught up in determining, okay, does this apply here or not, especially with remote work being so prominent. The first is, it just says ESTA applies to employees who are physically located in Michigan, regardless of the employer's location. So for example, I'm gonna use Mariel as my employee. And Mariel works for an employer based in Chicago, but she lives in Michigan and works out of her home office. She would be entitled to accrual and use of Michigan ESTA. Another example, or versus the rule, ESTA applies to work performed by employees whose employment is based in Michigan and that are sent out of state by their employer to work in another location. So for example, again, Mariel works for a Michigan-based company, but her employer sent her to their Chicago office within the same company to work. So while in Chicago, Mariel continues to accrue and use ESTA time, and that is compliant under ESTA.
And Anaria, I'm going to jump in here again, just because I know we got this question quite a bit. And I am sorry, Anaria is stuck with me because I spent the better part of last year going over the ESTA statute. But I just want to add, a lot of employers came to us and asked, and oftentimes when we have employers with remote employees, we say you should be looking to the state where the employee is located. And that example, which does come from the state FAQs that were updated in July of 2025, seems to indicate that well, if I am in Chicago, I'm still subject to ESTA. And I think the key provision here, and this is not entirely clear, and this example does not come from the statute, so it's really coming from the state's, interpretation. So it's not binding, but it is helpful. In that example, it specifically says the Michigan employer sends the employee out of state to work on a project. So this is not a situation where you have an employee who works in, let's just say Texas, who works in Texas entirely remote and chooses to be there voluntarily. It's unlikely that ESTA would apply in that situation. When it applies to your employees who are out of state is likely where you, the employer, are in Michigan, the employee is in Michigan, and then you are sending them to a different state to perform a project for a certain period of time. I do just want to highlight that because it was updated by that example was given by the state in July without any notice. And again, these FAQs are not binding. They just kind of provide insight into how the department may assess that situation. But I do recommend if you've got employees who are entirely remote by choice in another state, you should really be looking at those state policies to make sure that they're getting the applicable leave in those states as well.
Absolutely. Because another rule or interpretation that the FAQs provided regarding it may not apply to an employee traveling into Michigan for an employer when both are generally based outside of Michigan, unless that employee earns 50% or more of their compensation for the time spent in Michigan. So that's a rule that kind of hits on whether that traveling, if you're traveling back, like at what point do you reach the threshold of, okay, you work in Michigan, so this does apply to you. So it's less than 50% of their compensation, then it generally would not apply. As it applies to an employee accepting a Michigan-based job, though this was also something that me and Muriel discussed together, regardless of the employee's residency. So as she mentioned, it was, we would advise to just comply with whatever state they are in. But if you're working in, remote in a Michigan-based company, you may be covered by ESTA. But I do think if that's the case, it's so fact specific, you could, come to us and we can look into that for you.
I've got a couple more questions in the chat, Anaria.
Mm-hmm.
So first question, and this kind of goes back to the accrual versus front loading. There's an employer who uses the accrual method and policy for the probationary employees, and then they switch to front loading at the end of the probationary period. At that time, the employee's bank is loaded with everything they accrued during the first 90 days and a proration for the remainder of the year. And it's clearly defined in the policy. The employer's asking, is there a potential issue with this? And I would argue the state may look at this policy as a way to avoid having to give the front-loaded amount right away. I think you're opening yourself up to some risk. I think it is very likely the state will come in and look at this policy and say, and again, without reviewing your policy, this is kind of what I think would happen. I think the state would come in and say, this is really a front-loaded policy, and you're trying to get around the fact that this law requires all front-loaded time to be given immediately, not during a probationary period. So I do see some risk there. Now, again, without seeing the policy, it's difficult to tell, but I do see a potential concern there. And it's a good question because I don't think you're alone in structuring your policies that way. And then a question in the chat, just confirming that ESTA does not apply to 1099 workers, and that is correct. If you have a properly classified 1099 individual worker, ESTA would not apply. Now that said, that opens up a whole other can of worms and a whole separate presentation on ensuring that your worker is properly classified as a 1099 worker and not a W-2 employee. But yes, if they are properly classified 1099 individual, ESTA does not apply to that individual. Another question, if the employee lives in Michigan, but commutes to a work site in Toledo, is the employee eligible for ESTA? I do think this is probably one of those fact-specific examples that Anaria just went over. It probably depends on whether or not your work site the work site may be in Toledo, but if you are a Michigan-based employer, that may weigh in favor of giving this employee ESTA. It depends on if the employee is temporarily working on that Toledo site or if they're always working at Toledo. It is a good question. It's a little bit more fact specific, but you know, it's possible this employee is entitled to ESTA, I would say.
Yes, I would agree. Based on the examples given, it's definitely possible.
I would say, nobody loves the lawyer answer of it's possible. One thing you can do to kind of protect yourself, and it depends on your business, but you can always look at the Ohio paid leave laws and the Michigan paid leave laws and pick the one that's a little bit more generous, and then you've covered your employee in that situation. Obviously, if it's a one-off employee, that becomes a little bit more difficult. But if you've got a group of employees who fall under this category, maybe you create a policy for that group of employees. I don't think that Ohio has any mandatory paid leave. And the other thing, and I think you're going to get to this, Anaria, if I don't take up all your time, your existing PTO policy may offer sufficient amount of leave already, and you just need to make sure you've created those Michigan ESTA carve out. So there's a lot of options for that situation. It's just a matter of working out which one makes sense for your business.
Do we have any more questions, Miriam?
Nope, I think you're good to go ahead.
All right, thank you. So again, in ensuring that you are complying with ESTA, you want to again, there are certain duties that employers must that they are responsible for meeting, which again is providing the earned sick time, tracking accrual. We talked about the front loading method, the accrual method, and allowing use for qualifying reasons. This is something I wanted to come back to because there are, reasons that are outlined that you can refer to, and these are for employers or employees to check, but also employers to ensure that they know these qualifying reasons. It includes employees or family members' mental health or mental or physical illness or injury. If you as an employee or a family member, it has an incident involving domestic violence or sexual assault, that's a qualifying reason. Meeting at your child's school or place of care related to health or disability, domestic violence or sexual assault, that's a qualifying reason. If your employee's place of business, or I guess your place of business, is closed due to public health emergency, they can use the Michigan Earned Sick Time Act to take time away from work. Or as an employee, something that you should avoid doing is you cannot require an employee to search or secure a replacement worker as a condition for taking their earned sick time. So if they're taking it, if they meet these qualifying reasons and they have the proper time to take, they're free to take it. They don't have to find someone to cover their shift or come in and place them. And so earlier I mentioned a little as far as the qualifying reasons, family members, and those include your children, parents, grandparents, grandchildren, or an individual related by blood. And there's different, it's expansive. So just, children, that can be biological, foster, adopted, or parent, foster parent, step parent, adoptive parent. So there's a long list of family members that go into those qualifying reasons as well. So you want to, as the employer, know, and how you want to ensure that your employees know. And this is really important because, I've seen it being an attorney, you get a million questions from all your family and friends regarding everything you could possibly think of. But the main thing is something that I've gathered is that we or employees just don't know their policy and they don't understand it until it's an absolute necessity. Okay, I'm sick, someone's sick, I need to take time off. And then you go back to your handbook and you read it if you have one, and it's still unclear. So that's prolonging this emergency process that could have been, if you would have known as the employee, this is what I need to do to take my earned sick time, it would have been easier and just more streamlined.
And if your policy is not clear, you may end up paying out a wage and hour claim simply because the fight to establish your policy may not be worth the fines that are incurred. I would say we are starting to see the wage and hour claims for ESTA bubble up. I've had a few employers, and these claims are not too big yet. It's maybe a couple $100. But the employers that don't have ESTA policies are opening themselves up to much greater liability because if they fight the claim, even if the employee had been given the appropriate amount of time, without a policy, there are penalties within the statute if you don't give that separate written notice or you don't have the poster. And so it is really important to make sure that you have clear policies and your employees know how to utilize them, because if you don't, you may end up paying just to avoid further liability down the road. The other thing I would add to those permissible uses, the question I get all the time, especially when this first came out, was one of my employees' kids their school is closed because of snow, and they want to use ESTA. A snow day or closure because of snow does not fall under that Earned Sick Time Act. That came up more times than I was anticipating, so I do just want to be clear. I don't think it's always clear to employees, so a snow day is not a sick day.
Okay, and finally, we can talk about, that was a good transition to like common compliance mistakes. First, assuming that a general PTO policy satisfies ESTA, it does not. And those are those carve outs that Mario mentioned. Of course, you can allow for the required amount in your PTO policy, but you have to have specific carve outs for ESTA. Another thing is that you don't need as an employer, you don't have to separate the bank for PTO. You just have to, as far like the bank, as far as hours require, you don't have to have a separate bank, but you do want to ensure that the policy satisfies the ESTA requirement. Failing to define those qualifying reasons. So again, including no snow days, that does not count. And then if you're not updating your handbooks to include this required information. And finally, just inconsistent application across the board. Again, if it's clear and it's a standard set and it's outlined clearly for your employees through their policy, yes, things could happen, but it's better to just have these documents showing, okay, this is what is required. Or this is what we have to do in order for you to use the earned sick time accrued or front loaded into your bank. Here we go. So we want to remind you all in order to receive credit, we need you to put your answers into the survey. We're coming up on the last question, so I just wanted to provide a reminder for our attendees. And then our last question for today's seminar. Under ESTA, employees may accrue 1 hour of paid time for every blank hours worked. Here's our answer. All right, so that's all as far as content. I hope you all enjoyed and got some of your questions answered. If not, of course, I'll be happy to circle back, give you a call, and speak to you about any lingering concerns. Just as a reminder, as Mario mentioned earlier, we do have our next Breakfast Bite scheduled for June 16th, where Brianne Gilliam will talk about workplace investigations. So make sure that you are signed up for that and ready to go on the 16th. If you have any questions, we'll be here. We'll stick around to answer them.
There is one question in the chat, asking to clarify, is the separate written notice, at the time of hire, or can the ESTA policy be in the handbook signed off by the employee? The statute says it must be a separate written notice, and it requires some very specific, there's 5 requirements that must be in the separate written notice. I will tell you that the state has prepared they call it a brochure, that complies with the separate written notice requirement. My recommendation to you would be to include that brochure with your handbook, and have the employee sign off on that. And then you have to keep that record for, I believe, 3 years. If you don't have record of the acknowledgement of receiving the separate written notice, the department will assume that you didn't provide it. Technically, the separate written notice must be provided in both English and Spanish, and any language that 10% or more of your workforce speaks, provided that the department has prepared those materials for you. I can tell you that as of 2 weeks ago, the state had not yet prepared even the Spanish version of the separate written notice. It had just had the English version. But short answer to your question, best practice would be to have a separate policy outside of the handbook. You can give it to the employee when you hand the handbook over as part of the onboarding process, but a separate document is probably going to be your safer bet. To question in the chat, if we have an unlimited PTO policy but no paid time off in the first 90 days, should we indicate in the policy that the employee may use sick time only? That's probably not a bad idea. It'll give you some safeguard. We haven't seen how this statute will affect unlimited PTO policies, but arguably an unlimited PTO policy is similar to a front-loaded policy. And so yes, your safer bet would be to keep track of the employee using any ESTA in those first 90 days, and just be clear, you can use time for these enumerated purposes under the Michigan Earned Sick Time Act. Thanks, Brianne. Brianne has dropped the link for the recording and the slides that will be available on our website. And then a question for you, Anaria, should we list attendance expectations in our job descriptions?
Yes, that's part of that workplace expectation or workplace environment expectation best practice that I mentioned earlier. So if there are any attendance requirements, if you require 3 days in office, 2 days remote, or whatever the case may be, if it's as structured as that, which it should be, it can be outlined in that description.
Perfect. And then there is a question, does an at-will separation by an employer include the reason for the separation? Obviously, in Michigan, as an at-will employer, you can separate an employee for any or no reason, but you do want to be careful when you're having these termination conversations that if there is a reason, maybe there's some performance concerns. It may make sense to raise that in the separation conversation, simply because if the employee chooses to file some sort of discrimination complaint, and you told the employee, you're an at-will employee, and so we're just going to let you go. It'll be a little bit harder for you to make that defense when you say, well, it was actually for performance reasons, and here are all the reasons. I'm not saying in that termination discussion that you're giving the employee every single reason and every single failure for what they were missing. Ideally, you've had that conversation with the employee before, you've given them a chance to improve their behavior. The termination conversation is not meant to have all of the reasons for a separation. But if there is a reason and you may need to rely on that reason moving forward, in defense of some sort of discrimination claim, the employee should at least be on notice. Similarly, if you're wanting to protest unemployment, it'll be a lot harder for you to protest if you aren't transparent with the employee about the reason for the separation.
And I would confirm, I agree with Mariel. We've had this debate on, I don't even want to call it a debate. I am a strong believer that, again, while we're an at-will state, remember, at-will really just goes to the contractual rights. It says that you have a right contractually to terminate somebody at any time for any reason with or without cause. We still have to deal with statutory issues, and that is that the termination was not based on an illegal reason. And the way we show that is by, documenting and having a record that termination is based on performance or attitude or attendance. And again, in a termination notice, I hate seeing termination notices saying, we're terminating you on an at-will basis, and that's the basis for your termination. Because, if it's performance-based, to say, based upon your performance or lack of commitment or, just something general to give us the ability to articulate that, as opposed to having somebody point the finger at you saying, well, you told me I was just being terminated based on the at-will nature of my employment. You never told me it was performance-based or attendance-based or anything like that. I think it makes a lot of sense to articulate, even generally, the basis for separation.
I think we have time for just one more question, apt to end on an ESTA PTO question. If an employer has PTO and does not have a separate sick time off policy, can the employer determine what the PTO is used for? For example, if an employee needs to take time off for a child who is ill, can the employer reject the request? The Michigan Earned Sick Time Act is not voluntary. So while you can have a one bucket, is what I'll call it, PTO policy that gives an employee, let's just say 72 hours, the minimum for ESTA, 72 hours to use for whatever purpose. If the employee is choosing to use that PTO time for a purpose that is set forth under ESTA, you cannot reject that request. You have to allow the employee to take the time for the ESTA reason. And so in your example, you would not be able to reject that request. The employee is using PTO. You don't have a separate sick time policy, so your PTO policy must comply with ESTA. Otherwise, you will run into a potential wage and hour claim saying you violated ESTA. And so now, if you were to have a separate sick time policy, then you can dictate PTO can only be used for, whatever purposes you put in there. But if you've just got one policy, it must also comply with the Earned Sick Time Act. All right. I think those are all the questions, Anaria, so I'll let you wrap it up and we'll go from there.
Yes, well, thank you for joining us today. This was my second breakfast bite, so I was excited to do it, expand on my employment symposium presentation. So I appreciate you all for coming, and thanks to the panel for all joining as well.